Good day, everyone. Welcome again to the continuation of lectures on persons and family relations. Our topic for today are the rights and obligations of the spouses. Okay, this topic is important because in order to determine whether a person is psychologically incapacitated, it has something to do with the performance of the obligations, of the marital obligations of the couple. So, what are those obligations that are necessary in the discharge of your duties as a spouse? Okay, now Articles 68 to 73 will tell us of the basic rights and obligations of the spouses. Article 68 mandates that the spouses are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. So, marital cohabitation is one of the primary obligations of the couple. Mutual love, respect, and fidelity, as well as help and support. So, considering that they are uh, living together as husband and wife, the essential requirements for a harmonious relationship, such as love, respect, fidelity, helping each other, and supporting each other, are basic obligations of the spouses. Article 69 tells us about fixing the family domicile. Who has the right to determine the family domicile? So the Article 69 tells us that it is a joint decision of the spouses. And what if there is a disagreement as to where the couple shall live after the marriage? Then the court shall decide. So any of the spouses may go to court and seek aid from the court to resolve the dispute on the fixing of the family domicile. Um, Also, the second paragraph states that the court may exempt one spouse from living with the other if the latter should live abroad or there are other valid and compelling reasons for the exemption. Usually, the reason for the non-living together of the spouses is due to work because the other spouse is working in a foreign country. Okay. How about support? Okay. Article 70 tells us that the spouses are jointly responsible for the support of the family. So it is also a joint obligation. Um, the expenses for the support shall be paid, of course, from the community property because this is the default property regime of the spouses, or in the absence of a community property, from the income or fruits of their separate properties. In case of insufficiency, it shall be satisfied from their separate properties, if there is any. Okay. Article 71 tells us that the management of the household shall be the right and duty of both spouses. The expenses for such management shall be paid in accordance with Article 7. So, uh, the fixing of the family domicile, the support of the family, as well as the management of the household are joint obligations of both spouses. When one of the spouses neglects his duties to the conjugal union or commits acts which tend to bring danger, dishonor, or injury to the other or to the family, the aggrieved party may apply to the court for relief. So it seems that the court has no other option, but in case there is a dispute between the spouses, court relief may be availed of by either spouse. Article 73 also tells us that either spouse may exercise any legitimate profession, occupation, business, or activity without the consent of the other. So there is no requirement for joint consent of the spouses uh, whenever what is involved is the exercise of a profession, occupation, business, or activity. Okay, the only valid objection that can be given by the other spouse should be grounded on valid, serious, and moral reasons. Okay. Now, in case of disagreement, the court will decide whether or not the objection is proper, benefit has accrued to the family prior to the objection or thereafter. If the benefit accrued prior to the objection, the resulting obligation shall be enforced against the separate property of the spouse who has not obtained consent. Okay, so the validity, seriousness, and moral grounds invoked by the other spouse um, will be ruled upon by the court. So an example would be if one of the spouses want to go abroad in order to earn money to support the needs of the family, and the other spouse subjecting thereto on the ground that there would be separation and it would have created a toll on the family, especially if it is the mother who will leave for abroad and the children are still very young. So it can be considered as a valid ground, but the court will have to weigh the seriousness of such ground relative to the necessity that is invoked by the spouse who wants to go abroad. Okay, but the thing which is clear in Article 73 is that each of the spouses exercises autonomy on the right to exercise his profession, occupation, business, or activity. Okay. We now go to the case of Osorio versus Filter. Okay. The moral of the story that Osorio teaches us is that marital cohabitation is not a right. Okay. No one can force a spouse to live with the other spouse if he does not want to. Okay, so this is a case involving a husband and a wife. Okay, Erlinda and Potenciano. They have been separated, in fact, okay, for several years already. Okay, but Erlinda filed a petition for the issuance of a writ of habeas corpus for the purpose of compelling Potenciano, her husband, to live with her. Okay, now, can you compel marital cohabitation through the issuance of a writ of habeas corpus? The court said in the case of Osorio, marital union is a two-way process. Marriage is definitely for two loving adults who view the relationship with amor gignit amorem, respect, sacrifice, and a continuing commitment to togetherness, conscious of its value as a sublime social institution. Marital rights, including coverture and living in conjugal dwelling, may not be enforced by the extraordinary writ of habeas corpus. No court is empowered as a judicial authority to compel a husband to live with his wife. Coverture cannot be enforced by compulsion of the writ of habeas corpus. That is a matter beyond judicial authority and is best left to the man and the woman's free choice. Okay? Although marital cohabitation is a right as well as an obligation of the spouses, it cannot be compelled. It has to come from one's own free will. Okay? Another case is Atilano versus Beck. Okay, this case speaks of the obligation of support. Okay, Pilar filed a complaint for support against her husband, alleging that they have been estranged and living separately because of the dependent's inability to provide for themselves a home separate from the latter's parents. So, Pilar wanted to separate from her parents-in-law. So, she wanted a separate dwelling. Now, her husband refused on the ground that Defendant had the right to fix the residence of his family, and he is even willing to establish a conjugal dwelling in Manila separate from that of his parents if that was the plaintiff's desire. So the husband was saying that he is willing to provide a separate dwelling for the family, provided that it should be in Manila. He is given the option to fulfill the said duty either by paying the allowance as fixed by the court or by receiving and maintaining the person entitled thereto in his house, and that he elects to perform his obligation by the second means allowed him by law. So the wife cannot demand support from the husband because the husband is even willing to provide a separate dwelling, okay, for his family, separate from his parents. However, the wife is demanding that she lives separately from the family and asks support from his husband. The root cause of all their differences could be traced to disagreements common among relatives by affinity. We do not think that misunderstanding with in-laws who may be considered third parties to the marriage is the moral or legal obstacle that the lawmakers contemplated in the drafting of the said provision. Our laws contain no provision compelling the wife to live with her husband when even without legal justification, she establishes her residence apart from that. Yet in such an event, we would see no reason why she should be allowed any support from the husband. Why? Because she chose to live separately, even if the husband is willing to provide a separate dwelling for them. It appearing that the defendant availed of the option granted him by Article 299, and there being no legal or moral hindrance to the exercise of the second alternative, the answer to the question presented by this appeal is certainly obvious. So meaning, the wife is not entitled to be supported because she refused to live in the dwelling, in the separate dwelling provided for by the husband. Lua versus Lua is also a case for support. So, support consists of the basic needs, okay, needed for survival. Example would be food, dwelling or shelter, clothing, education, transportation. Okay. Now, what if the one who is obliged to give support, okay, provides for luxuries as gifts? Can you deduct them from the support which is required to provide? Okay, that is the issue in Lua versus Lua. Okay, the Supreme Court said the amount of support which those related by marriage and family relationship is generally obliged to give each other shall be in proportion to the resources or means of the giver and to the needs of the recipient. Such support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. In this case, the amount of provisional support may likewise consider the following factors: financial resources of the custodial and non-custodial parent and those of the child, the physical and emotional health of the child, the standard of living of the child, the non-monetary contributions that the parents will make towards the care and well-being of the child. When a father is required by a divorce decree to pay to the mother money for the support of their children, and the unpaid accrued installments become judgments in her favor, he cannot claim credit on account of payments voluntarily made directly to the children. So the value of the two expensive cars The cars are gifts. Okay? Uh, Travel expenses, purchases through credit card of items other than groceries and clothing should have been disallowed as these bear no relation to the judgment awarding support pendentility. So you cannot deduct them from the your obligation to support because these are gifts that are voluntarily given. Okay, so that's it for the rights and obligations of the spouses. Thank you for listening.